Hi, my name is Professor Dr. Devaruti Haldar, and in this session I am going to discuss about addressee under Section 2B of the Information Technology Act 2000, amended in 2008. The term addressee is specifically connected with another term called address. Physical address basically means any space where a person resides or carries on some official work or business. Virtual address, on the other hand, means any email address or any other virtual address, say for example a social media handle of the person where he can be communicated, a website through which the person owning the website or the companies owning the website or possessing the website can be communicated. Addressee, on the other hand, is a recipient of a communication. Let us now understand who is an addressee. We must remember the term address may not have uniform definition from the laws of India or any other jurisdiction, but the term addressee has been explained under Section 2B of the Information Technology Act 2000, amended by 2008. It is necessarily in connection with communication of electronic records. Let's now understand who is an addressee as per this provision. Section 2B of Information Technology Act 2000, amended in 2008, defines addressee as a person who is intended by the originator to receive the electronic record but does not include any intermediary. If we analyze this definition, what we get to see? The addressee must be a person. The addressee can receive an electronic record via any communication. The addressee must be the one the originator intends to send the communication to. The definition very clearly excludes intermediary from the definition of addressee. Is addressee the same as acceptor under the Indian Contract Act? Because when we define the term addressee, we actually can see a connection of the definition with Indian Contract Act, especially Section 4 of the Indian Contract Act 1872. Let us understand this. The term acceptor has been explained under Section 4 of the Indian Contract Act, which basically discusses about completion of communication of a proposal. The term acceptor has been defined or explained as a person who receives communication from the proposer, a person who has a right to accept or reject the proposal communicated or sent by the proposal, either by electronic medium or by physical letters. The acceptor must be residing in a specific address and must be eligible to receive some communication or proposal. On the other hand, we do get to see addressee is a person under Section 2B of the Information Technology Act 2000, amended in 2008, who receives the communication, and that specific person must be the person that the originator intends to send the communication to. The communication may contain electronic records. Rather, we should say, as per the Information Technology Act 2000, amended in 2008, an addressee must receive electronic records because the statute necessarily includes electronic records and also is intended for electronic communications and electronic commerce. There are different types of addressee under the Information Technology Act 2000, amended in 2008. Majorly, we can see two different types of addressees. One, a biological person, that is, a human being who is an individual recipient of the communication. He has got complete authority on his emails, on his other communication conduits, and he receives the communication, he understands the communication, he can react to the communication, and he understands the consequences of sending back the communication to the originator. Next is a juridical personality. This includes a state, companies, God, temples, institutions, and organizations. Sometimes we also do get to see animals as the addressee under the Indian Information Technology Act 2000, amended in 2008, especially when it falls within the meaning of juridical personality. In such cases, we get to see authorized stakeholder may receive the communication on behalf of the juridical personality and can take actions for such communication. Often, we get to see an addressee may become a victim. When such an addressee can become a victim? But please remember, we have already stated that the addressee can be a human being, that is a biological person, as well as a juridical personality. An addressee can become a victim when the addressee receives communication from the originator which can be criminally intimidating or insulting, or is a hate speech, or is a threat speech, or it is actually coming as part of stalking mechanism, coming as a part of sexually explicit communication, and so on. Further, the addressee, if the addressee is a juridical personality, can also be a victim, especially if there are cases like terrorism and cyber terrorism threat, intellectual property related victimization, and so on. Now, let us understand whether an addressee have locus standi in a court of law for restitution of justice if the addressee becomes a victim. The answer is yes, provided these certain conditions are met with. The addressee can be an individual recipient or a juridical personality, but the communication that has been sent to the addressee must be an offensive speech, and also there are proper evidences that the speech is an offensive speech, and if the addressee is a minor, then also the person has got locus standi in the court of law, especially the minor can contact the criminal justice machinery through different portals, himself or herself, but when the case goes to the courts, the minor can either be represented by an adult guardian or his parents. If the addressee becomes a victim, where to complain, where he can go for complaining, and what the addressee victim can expect from the courts? Definitely, if the communication contains offensive electronic records and communication, the first priority should be to go for the nearest police station. Or the addressee victim can also approach www.cybercrimes.gov.nic, which is the official portal for registration of cybercrime cases. The addressee victim must have the evidences of offensive communication. Remember, everything actually can be found in the electronic records and also in the digital footprints. Therefore, the addressee must not make a fake or false complaint, but always must have the evidences of the offensive communication that will enable the addressee victim to seek justice from the courts. The addressee victim can expect from the courts and also the criminal justice machinery rescue and rehabilitation, especially if such communication is something whereby the addressee may be put in physical danger. The addressee can definitely expect victim justice, compensation in specific matter, prohibition orders, especially against the originator senders, and the addressee can expect the courts to pronounce jail term for the accused, convicted sender or the originator of the communication. Thank you. For more understanding and knowledge on cyber law and other laws, please look into my site, Gender and Internet web magazine for law, which is available at www.internetlegalstudies.com. You can also connect with me through my email address profdebarati@gmail.com.